This human rights issue arises in the subject of employment law. Parties: the applicant is a worker, Patrick Henry McAuley. The original respondent was Ethigen Limited, a UK pharmaceutical warehouse licensed by the Medicine and Healthcare Regulatory Agency, MHRA. Ethigen was a warehouse who bought medicine and healthcare products from pharmaceutical manufacturers across the world, mainly Asia. They stored them in their warehouse to supply to European hospitals and pharmacies. Pharmacies and hospitals from across the Europe bought medicine and healthcare products from Ethigen, and then passed Ethigen's medicine on to their patients who were sick and requiring medical care. In June 2022, McAuley began working as a pharmaceutical picker-packer in Ethigen Limited. This meant that an order from a European hospital or pharmacy was paid for and submitted online to Ethigen. This order was then printed out by an Ethigen supervisor and handed to McAuley, and McAuley had to go round the Ethigen warehouse with a trolley to collect it in, scan it through the tills, pack it into a box, put the address label for the hospital's pharmacy on the box, and then leave it on the conveyor belt at the bottom of the warehouse, where the delivery drivers would pick it up and transport it to the hospital or pharmacy. At the beginning of a shift on McAuley's 9th day working in Ethigen, McAuley was ordered by his supervisor that he was not to do the pharmaceutical picker-packer work, but was instead bin man. Bin manner meant barehanded and without a luminous vest on. He was to go round all the warehouse bins and pluck brown boxes out of them. These bins throughout Ethigen's warehouse aisles contained brown boxes from medicine boxes on shelves being used up and tossed into them, as well as other general rubbish Ethigen staff discarded there. 1,000s of brown boxes were placed in aisle bins each day. Brown boxes with their structural integrity were to be raided, then taken to the tills so that hospitals and pharmacies' orders could be packed into these. If a new clean box was used to pack hospitals and pharmacies' medicine, this cost £2 to £10 each. This bin dipping by Ethigen for brown boxes for their orders saved £1,000 each day on new boxes costs. The brown boxes without their structural integrity were to be taken to the main bin outside and put in there. This involved McAuley dodging amongst heavy goods vehicles carrying wide loads, without a vest on. Many Ethigen picker-packer staff chewed gum as it was laborious work, and this assisted concentration. This meant that McAuley barehanded had to rummage amongst blobs of staffs where discarded chewing gum in the bins to get the brown boxes out. The boxes which hospitals and pharmacies' medicine orders were packed into previously had chewing gum and other rubbish inside them, and lying against the outside of them. McAuley asked his Ethigen supervisor if he could have a word in private to discuss concerns over this, and they duly went to a private spot in the warehouse. McAuley stated that he was concerned that this raised health and safety issues for staff and patients. The Ethigen supervisor told McAuley there was no discussing it and he had to do it immediately. McAuley asked the Ethigen supervisor if he could have the email address of senior management to make a complaint in writing about this. The Ethigen supervisor said that this would probably be fine, but before he allowed this, he wanted to discuss this with a fellow supervisor. Ethigen supervisor returned and told McAuley he to do bin duty immediately, or he was fired on the spot. McAuley, who needed the job and the money, stated that he was doing it under protest with a view to making a complaint in writing after his shift. McAuley did the bin manner work for the shift, putting most boxes into the main bin for hygiene reasons. 3 hours after the shift end time, McAuley received a text to inform him that he was fired. The reason provided to him was that Ethigen were not happy with his reply and attitude to bin duty. McAuley raised a complaint with the MHRA. The MHRA expressly affirmed that this was a whistleblowing on a dangerous workplace practice endangering both staff and patients across the UK and Europe. The court process in respect of this sacking then got underway. Alternative dispute resolution. McAuley sent Ethigen an intimation of claim letter for unpaid wages. Ethigen sent back a repudiation letter informing McAuley that he was lawfully sacked. On 5 occasions, McAuley requested the CCTV footage of the shift and for the days leading up to the shift. Employment Tribunal, ET, Glasgow. McAuley raised an ET1 form in the ET, Glasgow, for 1. Unfair dismissal, 2. Detriment, and 3. Harassment, seeking an order from this court for Ethigen to pay damages of circa £50,000. McAuley also did a disclosure for the CCTV footage he requested early in the process. The ET Glasgow duty judge sifted this ET1 as valid for service, so sent Ethigen an ET2 informing them that they had to answer to this in an ET3 form. Ethigen filed an ET3 denying liability and informed that they deleted the CCTV footage of these incidents. McAuley added a 4th plea for strikeouts for early requested CCTV footage of the incident's deletion. The ET Glasgow appointed employment judge Peter O'Donnell as the judge for this matter, and at a case management hearing he determined that this matter was to go to a 2-day trial, and that the only relevant witnesses were McAuley himself and the 2 supervisors in Ethigen. McAuley was deeply unhappy with this ET schedule and going to trial without the CCTV footage of the incidents under dispute. He appealed to the Employment Appeal Tribunal, EAT, Edinburgh, that only the Ethigen CCTV footage controllers should be allowed to give evidence, and if no good reason provided over CCTV deletion, then Ethigen liability defence is struck out, with a hearing only to ascertain damages owed and not on liability. The EAT Edinburgh judge Simon Auerbach arranged a hearing to consider this, so McAuley duly put in an application to the ET Glasgow that the hearing should be postponed until after the EAT hearing. The ET Glasgow judge O'Donnell refused to postpone, affirming he did not care if the EAT Edinburgh had arranged a hearing, and ordered that the 2-day ET trial he said was going ahead with or without McAuley. McAuley duly attended a standard 2-day ET trial, and so did the 2 Ethigen supervisors. 1 week later, E.J. O'Donnell dismissed McAuley's for pleas, determining that this was a lawful sacking. E.J. O'Donnell's legal reasoning for dismissal was to state for times that case law in 2001, 2002, 2003, 2004 expressly referred to legislation passed in 2013. This reasoning was unintelligible and quite frankly amounts to time travel by judges under Scots law. E.J. O'Donnell relied on 17 new documents in his judgment, which were not in the 400-page evidence bundle agreed, allegedly extracted out of the private MOJ database. E.J. O'Donnell took 17 no-context snippets of McAuley's alleged reactions to the CCTV issue and his delay refusal to strike him out, scandalous behavior. E.J. O'Donnell further stated that an employer could delete CCTV footage of a worker sacking incident. His reason for this was because the employer's supervisors could just give him precise evidence from memory. Employment Appeal Tribunal, EAT, Edinburgh. McAuley lodged an appeal with the EAT Edinburgh. McAuley argued that E.J. O'Donnell had erred in law over the 4 pleas: 1. Unfair dismissal, 2. Detriment, 3. Harassment, and 4. Strikeout for CCTV deletion of sack incident. McAuley further argued that the 17 new documents dated months before allegedly referring to no-context quotes attributed to him he had not seen at trial, did not recall saying, were not in the evidence bundle, and at best were wildly out of context and doctored into a ludicrous scrapbook, was not valid evidence. McAuley received an EAT 1993 Regulations, Rule 3.7, strikeouts letter from EAT Judge Casper Glynn KC. EAT Judge Glynn stated that the case law in 2001, 2002, 2003, and 2004 supposedly referring to legislation not passed until 2013 was model reasoning. One must presume frankly the model being referred to was the DeLorean. EAT Judge Glynn also stated that referring to 17 new documents not in the evidence bundle and not put to the witness was relevant and properly referred to. EAT Judge Glynn supported employers in the UK being allowed to delete early requested CCTV footage of a workplace sacking incident of a worker because the supervisors can just give rough evidence about it from memory. McAuley contested this Rule 3.7 letter, so the EAT arranged a 3-hour strikeout hearing, a 95% strikeout rate hearing which only McAuley attends, but Ethigen can listen to and make submissions if they choose. UK Government, Ministry of Justice, MOJ. McAuley wrote a letter to the MOJ, the employer of judges, to inquire about E.J. O'Donnell referring to 17 new private documents allegedly from their database. The MOJ affirmed this was unlawful by E.J. O'Donnell. Supreme Court of Scotland, IHCS, Edinburgh. McAuley appealed to the Supreme Court of Scotland, in a House Court of Session, Edinburgh. He appeared there in person alone, Ethigen didn't go, before Lady Moragwise KC in a leave to appeal hearing. McAuley expressly read out Regulation 3.7 of Employment Appeal Tribunal Rules, ECtHR 1993, stating that a Rule 3.7 letter could only be issued by an judge if 1. There were no reasonable grounds for an appeal, and 2. That the Employment Appeal Tribunal judge wrote a letter with reasons in it. McAuley argued that the Employment Tribunal adding 17 new documents into the judgment, which were not in the evidence nor put to him at the hearing, was an automatic reasonable grounds for an appeal, especially a 50k damages hearing where he was now likely liable for 50k expenses to 100k flip. He argued a Rule 3.7 letter being issued in these circumstances breached ECtHR 1993 Regulation 3.7. McAuley further argued that if there was CCTV footage of a workplace sacking incident the worker requested to prove an unfair sacking, and the worker lost, there was an automatic reasonable appeal ground. McAuley also argued that the Rule 3.7 letter calling reasoning, which amounted to time travel by Scots law judges as model, was not a reason, so a Rule 3.7 doing so breached ECtHR 1993 Regulation 3.7. McAuley invited Lady Wise to reduce as unlawful the Rule 3.7 letter and the EAT strikeout hearing, and order that McAuley v. Ethigen proceed to a full hearing in the Employment Appeal Tribunal. Lady Wise dismissed the application, refused leave to appeal, and refused to grant the order sought. Lady Wise affirmed the 95% rate EAT strikeout hearing was to go ahead in this McAuley v. Ethigen scenario. Lady Wise simply deemed that the Employment Tribunal Glasgow inserting 17 new documents into the judgment, which were not in the evidence bundle, was a valid practice and not an automatic reasonable appeal ground. She stated that an employer deleting early requested CCTV footage of a workplace sacking incident and then the worker losing was not an automatic reasonable ground for at least a second opinion appeal either. Lady Wise stated that because the Rule 3.7 reasons were 5 pages, these were valid reasons. She even stated that an EAT judge could indeed use reasoning amounting to time travel as a reason for a decision if they wanted. She concluded that for judicial reasons quantity was more important than quality. United Kingdom Supreme Court, UKSC, London. McAuley appealed to the UKSC arguing the EAT strikeout hearing was a violation of Article 6, ECtHR. 1. He argued time travel was not a valid reason for a strikeout letter, and 2. A strikeout letter being sent after 17 new documents not in the evidence bundle nor referred to a trial were entered into the ET judgment violated our access to court. McAuley again argued that if there was CCTV footage of a workplace sacking incident, which the worker requested to prove the sacking was unfair, and the worker lost, not granting an appeal for a second opinion in those circumstances was a violation of access to court, and amounted to a modern slavery for British workers. McAuley made the plea for the UKSC to reduce as unlawful both EAT Judge Glynn's Rule 3(7) letter and Lady Wise's IHCS judgment, and order that McAuley v Ethigen proceed to a full hearing in the ECT. Lord George Leggat KC made a UKSC direction in this matter. He bluntly refused and banally stated that claims the EAT strikeout hearing was a violation of Article 6 or any other ECtHR article was baseless. McAuley contested this and called for a public hearing in the UKSC where the ECtHR compliance of the EAT strikeout hearing could be contested in open court before the British public. This is a right all British workers possess under the UKSC rules of court, and McAuley as a British citizen exercised this right. Lord Leggat and the UKSC simply ignored this worker's right and refused to call a public hearing in UKSC. EAT, Edinburgh. The EAT were informed of this by McAuley. They duly arranged for the strikeout hearing on the 30th of June, 2025. McAuley made a motion for McAuley v Ethigen to be a full hearing and not a strikeout hearing. EAT Judge Albach refused this on the 14th of January, 2025 and insisted a strikeout hearing was to be used in a case like this. European Court of Human Rights. We have now finally reached the top of the mountain, the European Court of Human Rights. McAuley is arguing before the Council of Europe that the recommendation should be made that the EAT strikeout hearing in Edinburgh, scheduled for June 30th, 2025, is a violation of Article 6 ECtHR, and should be upgraded to a full hearing. McAuley is also arguing before the Council of Europe that the recommendation is made that the UK's dismissive attitude towards an organisation deleting CCTV footage of a workplace sacking incident is a form of modern slavery in violation of Article 4 ECtHR. It is seeking for the Council of Europe to recommend the UK that if CCTV footage of a worker sacking incident is requested early, and the organisation deletes this, then the organisation should be struck out for this without a trial going ahead, and if a trial does go ahead and the worker loses, the least a worker is entitled to is a full hearing in the appeal court for a second judicial opinion. Please subscribe to find out how the Council of Europe deals with this case.